Welcome to the deep dive. Today, we're tackling what is, probably the most critical decision point in all of contract law, that moment when a deal just breaks down.
Right.
Because it's not enough to just say someone breached. Our mission today is to analyze the legal architecture that dictates what happens next. Does the injured party just get a check for damages, or do they get to walk away from the whole deal?
And that distinction, that's the whole ballgame. It's the difference between a remedy and a complete excuse from your own performance.
Mm.
So to really get this right, we have to look at four key areas.
Okay.
First, we'll distinguish between a promise, which creates a duty, and a condition, which limits a duty. Then we'll dig into the different rules the common law and the UCC for goods use to decide if a breach is, serious enough to justify walking away.
I like that framing. Duty creating versus duty limiting. So let's jump right in. Why is that initial difference between a promise and a condition so absolutely fundamental? Why can't it just flip the entire outcome?
Well, it all comes down to the consequence of failure. If you fail to perform a promise, the other party gets damages. But if a condition fails to occur, the other party's duty to perform is just excused. It vanishes.
That sounds harsh.
It is. And here's the really harsh part. If a court finds a term is an express condition, performance has to be exact. That doctrine of substantial performance, it generally doesn't apply. Being close enough is just not good enough.
So you could lose the entire benefit of a contract over some minor technicality. That feels, well, wildly unfair. Given that courts usually dislike that kind of result, how do they handle language that's a bit ambiguous?
They have a very strong preference. Because of that risk of forfeiture, there's a fundamental rule of construction. If language is ambiguous, courts will construe it as a promise, not a condition.
Okay, so they lean towards keeping the contract alive.
Exactly. It keeps the deal on track and allows for damages rather than a total and potentially devastating termination. The intent to create a condition has to be crystal clear.
We need to see how that works in practice. Let's analyze Rohauer v. Little. It seems like a perfect example of this anti-forfeiture idea. So, first, what are the legally dispositive facts?
Okay, so you've got a basic land sale agreement. The contract stated that the abstract of title, quote, shall be furnished to the purchaser on or before July 10th, 1981. The seller missed that deadline by just a few days, and the buyer immediately tried to back out, claiming the entire deal was off.
And what was the core legal issue?
The central question was this. Was that deadline an express condition precedent, which would excuse the buyer from their duty to purchase, or was it just a promise, which would only give the buyer a right to damages for that small delay?
What rule of law did the court apply here? Can you state the full black-letter rule and break down its testable elements for us?
Yep. The court applied that rule of construction preferring a promise to avoid forfeiture. And that rule has really just one critical testable element. Did the contract language unequivocally state a condition? If yes, it's a condition. If no, the court defaults to treating it as a promise.
Thank you. So now for the court's elemental analysis. Let's walk through this. How did the court apply that single element, unequivocal language?
The court looked at the phrase, shall be furnished. And, while that sounds mandatory, it's historically been seen as language that creates a duty, a promise. It didn't have those magic words like on the condition that, or if and only if. So because the language was at least a little ambiguous, that element of unequivocal conditional language was not met.
And after analyzing that one element, what was the court's final conclusion?
The court held that the term was a promise. And because the seller had, substantially performed the contract aside from that minor delay, it was actually the buyer who breached by walking away. The seller won, which really shows how powerful that judicial preference against forfeiture is.
That commercial context seems to matter a lot. So let's take that idea to a more specialized area. Those pay-when-paid clauses you see in construction contracts. If a subcontractor is told they'll get paid when the general receives payment from the owner, what happens if the owner never pays the general? Is the sub just out of luck?
Generally, no. Courts almost always construe those clauses as being about the timing of payment, not whether payment is owed at all. So it's a promise to pay within a reasonable time.
And what's the thinking there?
The policy is really key. The courts recognize that small subcontractors are in a terrible position to judge the owner's solvency or to bear that risk. So to shift that entire risk onto the sub, the contract has to do so unambiguously. The language has to be so clear that there's no other way to read it.
That's a great policy insight. Now, before we move on to breach, let's just quickly classify conditions. You hear about condition precedent, concurrent conditions, and condition subsequent. Why do those labels even matter?
They matter for one main reason. The burden of pleading and proof in court. It's all about who has to prove what.
Okay, so break that down for us. Who has the burden for a condition precedent versus a condition subsequent?
So for condition precedent, the burden is on the party who wants to enforce the promise. They have to prove the condition happened. But for a condition subsequent, the burden shifts. It's on the party who wants to avoid their duty. They have to prove the subsequent event occurred that excuses them.
Let's use a hypothetical to really make that stick. Imagine an auto insurance policy. The insurer's duty to pay kicks in when you have a covered loss, but the policy says you have to notify them within 10 days of an accident. If you're late, their duty is excused. What kind of condition is that, and who has to prove what?
That's a classic condition subsequent. The duty to pay already exists because the loss happened. So if the insurance company gets sued, it has the burden of proving that the 10-day notice didn't happen in order to get out of its duty to pay. The burden is on the party trying to get out of the deal.
That really clarifies it. Okay, let's pivot now to common law promises. When a promise is breached, how do we know if it's serious enough, if it's material, to let the other side just walk away?
Now we're in the world of substantial performance. Under common law, you fulfill your duties as long as you don't commit a material breach. If the breach is material, that's a failure of a constructive condition, and the other party can suspend or terminate. But if the breach is minor, they still have to perform their side of the deal and can only sue for damages.
So how do we find that line? How do courts figure out what's material? Is there a checklist we can use?
There is. It's a mandatory checklist of 5 factors, really, from the restatement. And while they all matter, the first and the last are usually the heavy hitters.
Okay, what are they?
1, the extent to which the injured party is deprived of the benefit they reasonably expected. That's the big one. 2, can money damages adequately compensate them? 3, can the breaching party fix or cure the breach? 4, was the breach in good faith or was it willful? And 5, the extent of forfeiture the breaching party will suffer if we call the breach material.
Let's apply those factors to probably the most famous case on this topic. Jacob and Young's Inc. v. Kent, the Cardozo opinion. First, what are the legally dispositive facts?
All right, so a builder is constructing this very fancy, expensive country home. The contract is incredibly specific and says all the plumbing pipe has to be Reading brand pipe. By mistake, the builder installs Cohoes brand pipe, which, and this is key, was proven to be of identical quality, trice, and durability. The owner, Kent, finds out and refuses to make the final payment of about $3,000.
And what was the core legal issue?
The issue was whether using the wrong brand of pipe was a material breach. Did that mistake prevent the builder's work from being considered substantial performance, thereby excusing the owner's duty to make that final payment?
What rule of law did the court apply? Let's break down the black letter rule and its elements, especially the 2 that were most important in this case.
The court applied the doctrine of substantial performance. The rule required testing for material breach using those 5 factors, but Cardozo's analysis really focused on 2 critical elements here. Number 1, the deprivation of expected benefit, and number 2, the forfeiture suffered by the builder.
Thank you. Now for the court's elemental analysis. Let's go step by step. How did the court apply that first element, deprivation of expected benefit?
So the sub-issue here is, did the owner fail to get the essential benefit of his bargain? And since the co-host pipe was functionally identical, same quality, same value, the court found that the owner was deprived of, well, basically no practical benefit. The house had perfectly good plumbing, so that element weighed against finding a material breach.
Understood. Now what about that second element, forfeiture to the breaching party?
Here, the court looked at the cost to cure the defect. And the only way to replace the pipe would have been to demolish huge sections of the newly finished house. The court said that would result in a grossly disproportionate forfeiture for the builder, tearing down the house over a trivial defect in brand name. So this element also weighed heavily against materiality.
And after analyzing those key elements, what was the court's final conclusion?
The court held that the builder had achieved substantial performance. The constructive condition was met. Kent, the owner, had to make the final payment. He could, in theory, sue for damages, but the difference in value between Reading and Cohoes pipe was 0.
So for services and real estate, substantial is good enough. Courts hate forfeiture. But what happens when we shift arenas to contracts for the sale of goods under the UCC? Does that forgiving standard still apply?
No, absolutely not, at least not for single delivery contracts. The UCC has a much, much stricter standard. It's called the perfect tender rule.
Perfect.
Right. It means the buyer can reject the goods if they fail in any respect to conform to the contract. Even a tiny non-material defect is grounds for total rejection.
Let's see that in action. Tell us about Ramirez v. Autosport. What are the core facts there?
The buyers bought a new camper van. When it was delivered, they rejected it because of several pretty minor defects, a few scratches in the paint, some missing interior hookups, and the seat cushions were a bit damp.
And what was the issue and conclusion on the perfect tender rule?
The issue is whether those small fixable problems were enough to justify rejection. And the court said yes. Under the perfect tender rule, the van failed in any respect to conform, so the buyer's rejection was perfectly justified. Something that would have been trivial under common law was a deal breaker under the UCC.
Wow. That seems to open the door for buyers to reject for any reason, maybe if the market price drops. Does the seller have any protection against that kind of opportunistic behavior?
It does. The UCC balances that harsh rule with a very important protection for the seller's right to cure. This is a big deal. If the time for performance hasn't expired yet, the seller can just notify the buyer and deliver conforming goods. And even if time has expired, the seller might get more time if they had reasonable grounds to believe the non-conforming goods would be acceptable.
So perfect tender is the rule, but the right to cure provides a safety valve. Okay, one final UCC wrinkle. What about installment contracts, where goods are delivered in batches over time? Do we still use that strict perfect tender standard?
No, we don't. The law recognizes that demanding perfection across, dozens of deliveries is just not commercially practical. So for installment contracts, the UCC actually abandons the perfect tender rule and goes back to a materiality standard.
Really? So it's more like the common law then?
It is. A buyer can only reject one installment if the defect substantially impairs the value of that installment. And to cancel the entire contract, the problem has to be even worse. It has to substantially impair the value of the whole contract, which usually means a pattern of serious failures. So to pull all this together, here is the diagnostic checklist you should run through for any contract performance problem. Step 1. Identify the nature of the term. Is it a promise or a condition? Remember, if it's ambiguous, courts will lean towards promise to avoid forfeiture. Step 2. Identify governing law. Are you in the world of common law for services and real estate? Or UCC Article 2 for the sale of goods? This is the most important fork in the road. Step 3. If it's common law, you apply the materiality test. Run through those 5 factors, focusing on deprivation of benefit and forfeiture. Only a material breach will excuse performance. Step 4. If it's UCC goods, you apply the right UCC rule. A single delivery triggers the very strict perfect tender rule. But an installment contract brings you back to a materiality test, substantial impairment. And finally, Step 5. Always check for cure. Whether under the UCC or common law, did the breaching party have a right or ability to fix the problem? Because if the injured party wrongly refuses to let them cure, they might just become the new breaching party.
That is an incredibly useful framework. We saw in Jacob and Young's how far courts will go to prevent forfeiture over a technicality. But at the same time, the law has no patience for the willful transgressor, the person acting in bad faith. So if you know courts prize good faith and the essential purpose of a deal over rigid literalism, what does that mean for how you should conduct your own business? Do you aim for technical perfection, or do you focus on demonstrating good faith and delivering the core of the bargain? That tension is really the key takeaway here.